Good morning, everybody. I am super excited to have this amazing presentation going on. As you already know, it is Halloween week. I feel like everywhere I've been going around, there's a lot of Halloween decoration. Everybody's just in the mood for some Halloween vibes. But let me tell you right now that if you ever are faced with this type of claim, wage an hour, that is definitely not somewhere where you want to be, and it is literally California's nightmare. If any of you guys have experienced it, you guys know very well what I'm talking about. So I'm very excited to have Mr. Brandon Silva, who is a defense labor law attorney, and he's going to let us know about PAGA and how we could pretty much protect our business. So, Mr. Brandon, do you want to introduce yourself to the audience?
That's fine with me. I'll dive right in. Welcome, everyone. As Rocio said, my name is Brandon Sylvia. I'm a partner at Rattan & Tucker. I've been there nearly 20 years, and for my entire career have specialized in employment law. And so that encompasses things like harassment, discrimination, retaliation, wrongful termination, as well as the claims we're going to talk about today. So wage and hour claims. And wage and hour claims get the scariest when it's not just one person that we're talking about, one person's unpaid wages or meal break issues. When we're talking about all of your employees' meal break issues or unpaid wages, and we get that presented in the form of either class actions or the more popular flavor of about the last decade, these PAGA claims. Okay, and so I bring, as someone that defends companies, I bring a bit of a defense bent to the way I view these things. Some of my approaches to these things might be different than what you hear from your HR professionals, because I actually litigate these things. I go to court in an arbitration and I see how the evidence comes in and I see how the law gets applied to it by judges and by arbitrators. And so that's kind of the perspective that I bring. I've got probably more slides than we can get through in depth today. I've got presentations I've done on PAGA that have lasted 60 or 90 minutes. We've got about 30 minutes today, and I'd like to save, minutes at the end at least for questions. So we're going to dive right in and move at a pretty aggressive pace. So without further ado, hopefully everyone can see my screen. I'll tell you a little bit about PAGA, what it is, why it's the nastiest four-letter word in California, and some of the recent changes to the law that were enacted just over a year ago. We'll talk about your most common risk areas, and then kind of touch on ways to avoid the particular downfalls in those areas, and then pre and post litigation risk mitigation strategies, which really come into place in particular because of the new updates to PAGA. So by way of background, the Private Attorneys General Act of 2004 is what we're talking about, but we all say PAGA. Even though it was around in 2004, it took a long time for this to really catch on as the most lucrative kind of claim you might find in California. But over the years, there have been billions of dollars in PAGA settlements. Just to give you a brief idea, there's nearly 25,000 PAGA notices filed in the 4 years between 2016 and 2020. There's been at least that many again in the last 5 years. And these are big cases. So the average settlement is over $1 million. These are cases that are brought by plaintiffs' employment counsel who are always on contingency. Okay. And so they get paid based on taking a chunk of the settlement. It's the commercials you see every morning on TV. You don't pay unless we win. Well, you, as in the plaintiff, never pays. It's the defendant, the employer, that's paying. And it's usually about a third or 35% of the attorney's fees, which is why that average amount per case is north of $350,000. The plaintiff's average amount is about $8,000, and in some cases it's even less than that. And the reason I put that information up there is because you need to understand this is not about the plaintiff or the person suing you. This is about the plaintiff's attorney. They're the ones who profit from this, and so they're driving the case. typically when you mediate these cases, the plaintiff doesn't even attend, okay, which is not the case in virtually every other type of litigation. And we're talking a lot of these cases filed here in LA and Orange County. My office is in Irvine, so we're right next to Orange County Central Justice Center, but we litigate throughout the state, and OC and LA are where we see the most of these. Last year, we had a ballot initiative that was going to potentially repeal PAGA, and the state didn't want that because when PAGA claims are settled, a big chunk of the money after the attorneys get paid gets paid to the state of California. It's a huge revenue generator. And so Gavin Newsom stepped in. There was a deal brokered to keep this ballot initiative away from voters in exchange for some reforms. And we'll talk about what those reforms are right now. So some of the reforms to PAGA, we redefined what standing means, right? PAGA is like a class action in the sense that one person sues you and represents lots of other employees, all of your non-exempt employees in the last year under PAGA. And if that person under the old PAGA could prove one meal period violation, they could chase you for every other labor code violation under the sun on behalf of everyone else. That's no longer the case under new PAGA. So that's actually a really good way to rein it in. We're only going to be on the hook for labor code issues that one plaintiff can prove that they themselves sustained. There's also some rewards for proactive compliance that we'll talk about towards the end of this. The quick takeaway is that under the new PAGA, you can have a reduction in the total amount of penalties at issue if you act to really polish up your policies and practices with regard to meal period compliance, wage payments, and other labor code issues. There's also a bit of an expanded cure. There was very limited ability to fix these issues. You were just in the soup immediately as soon as someone sent in a PAGA notice. There's a little bit of an expansion of that now that we'll talk about later as well. But it is some good news in this PAGA reform. And then there's penalty reductions in terms of what gets paid to the state of California. And also in terms of the dollar amount of the penalty at issue. It used to just be basically when you were trying to resolve one of these cases or value one of these PAGA cases, it was $200 per violation per employee per pay period. And so it's just a multiplying system that makes it very expensive very quickly. The good news under new PAGA is that we're not getting to that higher $200 per penalty amount unless you've already had a PAGA lawsuit and got in trouble for that. All right. So I know I'm flying through this. That's okay. The takeaway again is that we're under a new PAGA regime, and there are some things you can do proactively to help yourself because of that new law. So let's get in kind of the nuts and bolts. With PAGA claims, what we're talking about are labor code violations, right? The labor code is laws on the books in California. There's also some wage orders. But these are the things that employers have to comply with. And labor code compliance is really difficult because, you may be an employer thinking, hey, I treat my people well. I make sure they get paid. Nobody's ever complained. I'm probably fine. And you might not be. You could be, but labor code compliance is nearly impossible to be perfect. And perfection is the standard against you are going to be measured in a piece of PAGA litigation. It doesn't matter if it was an accident. It doesn't matter if you didn't mean to underpay employees. It doesn't matter if you didn't understand the law. If there are labor code violations, you're dead in the water. That's just the way these things work. And so the big risk areas are in these categories here, which again, I know I'm going to fly through it. I can circulate this PowerPoint either through Rocio or directly to everyone so you have the materials. But we're just going to talk briefly about some of these big issues and then ways in which you can address them. So meal periods and rest breaks, right? Meal periods, hopefully, that your non-exempt employees are entitled to a net a meal period of not less than 30 minutes for shifts in excess of 5 hours within the first 5 hours unless they don't work beyond 6 hours, right? And so we hear about the 5-hour rule. I see employers mess that up all the time, right? What is the 5-hour rule? How many hours do you work before you click into your 5th hour of work, right? When you've worked 1 minute, you're into your 1st hour. So technically, when you click over to 4 hours in 1 minute, you're into your 5th hour. What does this mean? And I'll show you on a chart that I break it down in the next slide very simply what the 5-hour rule actually is. Some rest break policies will get you in trouble as well. Do employees get 2 rest breaks per shift? Well, that's not what the law says, right? It's a net 10-minute rest break for every 4 hours worked or major fraction thereof. And so, yes, that does usually equate to 2 hours for an 8-hour shift. But if they work 10.5 hours, we're not talking 2 rest breaks anymore. And your policies in this regard, they just need to be perfect. And that's again, perfection's difficult, but when you're writing a policy, we just make it mirror the law and make it simple for employees. Most common mistakes, right? Untimely, meaning they work too many hours before taking a meal period. Your employees might not clock out for the full 30 minutes, or they might not clock out at all, which looks like a missed meal period. I see employers sometimes that automatically deduct 30 minutes from employees' time because they know or assume a meal period is taken. That's a no-no for reasons I can discuss. And then if your meal period policies require on duty or the employees to remain on premises, those are going to get you in trouble as well because they have to be duty-free 30-minute meal periods, meaning don't take a walkie-talkie with you. Don't be subject to being called back for an emergency. With regard to rest breaks, some employers say, well, this guy, spends 30 minutes in the bathroom every day. Surely he's getting rest breaks. Well, no, rest breaks are not restroom breaks, and we shouldn't be combining those necessarily. Employees are free to use the restroom on a rest break, but don't say that a restroom break is a rest break. Employers also get in trouble when they don't have adequate coverage for an employee to actually take a rest break. They may have a great policy, but the reality is there's only one person working the station, working the line, and then that person can't physically take a rest break because there's no one to relieve them. Interrupted rest breaks and then on duty and on premises. We had a case from a couple years ago. It was over $100 million judgment, this Augustus case, that came out and said rest breaks also have to be duty free. And that's even though the statute doesn't say anything about duty-free rest breaks. So that was a real sucker punch. You're free to, by the way, put comments into the chat while I'm flying through this stuff. I'm going to save them to the end of the presentation just in case they get answered by the material. But I'll come back to them and go through them. So I see you out there, Maria. So here's a quick chart that I think is pretty useful. I like clients to post this in break rooms and put it in their handbook and put it everywhere if you can, because it breaks it down. It's almost too simple to screw up, hopefully, with regard to how many breaks, when do you take them, how long are they? Next big danger area is overtime and regular rate calculation. I got into being a lawyer not because I loved math, and the regular rate calculation does involve a decent amount of math. So I'm going to go quickly through this as I am everything else. The issue here is the concept is, like, I know you have your hourly rate, right? Let's say you're $20 an hour. Okay, well, your overtime rate then is $30 an hour. Simple math. Even I can do that. Now, the regular rate is different than your base hourly rate. And overtime has to be paid based on your regular rate, as do meal period and rest break penalty payments. So how do you figure out a regular rate? Well, you have to take all compensation that is non-discretionary, like bonuses, attendance bonuses, split shift, not split shift, but like graveyard shift, differentials, things of that nature, commission payments, and then bonuses that they are kind of guaranteed if they hit their targets. Those things come in to the regular rate calculation. So you take all their earnings divided by all their hours, and that'll give you their regular rate. It's usually very close to their base rate, but it's not the same. And again, we're going to get judged on a scale of perfection here. So we got to make sure we're doing this right. definitely want to look at our pay
And then,
code.
sorry to interrupt you, Brian, just real quick, just because I have contractors, who follow me, and some of them 1099 their employees, or they have them W-2 and commission, but they have some of them don't know what hourly rate and how to define what's legal to, like, I guess what's the legal, is there a legal commission that people need to give, a commission structure, or like a minimum base salary, or base hourly for salespeople?
Right. So, one of the things they teach you in law school, the right answer is nearly always, it depends. And it does depend. If someone's actually properly classified as a contractor, which is a rabbit hole we won't go down today, but if anybody has questions, I can help answer. It's very difficult to classify someone properly anymore in California as an independent contractor following the ABC test. Contractors don't have a minimum wage. If the person is properly classified as an outside sales representative, that's an employee classification, but it's one that's exempt. And it's exempt from virtually everything, including a minimum wage requirement. So if you have a outside salesperson that is properly classified, there's a legal test that tells you if someone can be classified as an outside salesperson, then no, there isn't a minimum wage. If the employee is not an outside salesperson, then you've got all sorts of situations where it should not be just commission only, because you've got non-productive time like a rest break, you've got minimum wage issues, and a whole ball of wax that you got to deal with in that way. So
Yep, but we got the questions coming in.
That's okay. I'll get to them. Next area, scary area, time punch rounding. Were we in person? I might ask for a show of hands to shame those who still round their time punches. I've been on this train for at least 10 years. If you're rounding, you shouldn't be. Don't do it. I can tell you 100 horror stories why I'm right on this. I just settled a case last week where 40% of the people didn't lose time because of rounding, and 60% did, and it was a nearly $300,000 settlement for not a very large class. We got them a great deal, to toot my own horn for a second. But rounding causes problems, even though it's lawful under federal law and technically sort of lawful under California law. Having litigated these cases for so long, rounding policies almost always result in people not getting paid for every minute of their time, which creates labor code violations, which hammer you. And yeah, it's just a few minutes a day, but when you extrapolate that over hundreds of people throughout your workforce, and then you tack on attorney's fees and penalties and waiting time penalties from people claiming, well, now I didn't get paid all my wages when I was let go, it just goes very quickly. So if you're rounding, don't do it. Off the clock work is another similar one. The concept here is someone is not being paid for time that is technically considered work time. So sometimes you have policies that say you can't clock in until your scheduled shift start time. Okay, what does the person have to get there and don and doff equipment beforehand? Do they, are they waiting to be let into the work area? That kind of waiting time, temperature screenings. We saw lawsuits through COVID about this, bag checks for security, for your administrative people if they have after hours email or remote access and they're checking email at night. That is technically working time for which they need to be paid. So off the clock work can cause you all kinds of problems as well. We see remote work challenges. I don't know how many of you this is going to apply to, but even remote workers, we all got very educated on this during the pandemic. We still have to record start and stop times of work each day. We still have to record meal period start and stop times, and we still have to make sure employees are taking them, which is kind of crazy. But welcome to California. It's not the craziest thing you'll hear probably even in the next 10 minutes. So you also have expense reimbursement issues, which we'll talk about kind of separately in a moment. Oh, here we go. Quick moment. Expense reimbursements. This is not just your non-exempt hourly employees. This is for your executives as well. We've seen a ton of these type of claims come through following the pandemic, because when people started working from home, well, now they're using electricity and internet for which they're paying but that they're using for the employer's benefit. And so that dynamic is one that caught a lot of employers off guard. Usually it was just, well, if you have to wear a certain uniform, I'll pay for it and I'll pay for your mileage. Those are expense reimbursements, right? Yes, but there's a lot more than that. And so especially if you have work from home people, we need to be thinking about that. If you have policies that are, you use it, you break it, you buy it kind of policies, right? You got iPads in the field and you got employees who are breaking them, then you're going to charge them for that. That'll get you in trouble under Labor Code 2802 as well. Then wage statements, right? Everyone is entitled to get a wage statement that is accurate and itemizes information. This is all the information that needs to be on it according to Labor Code Section 226. You also have to have accrued paid sick time down there. That's in a different Labor Code section. That one sometimes catches employers off guard. If in the last year you haven't taken a look at a non-exempt employee's wage statement and compared it to the requirements of Labor Code 226 or had your counsel or HR person do it, you need to do it. Gremlins creep into these things. And then arbitration agreements. I add this not because it's a labor code violation, but because California is very hostile to arbitration agreements. As a defense attorney, I love them because they can cut the legs out from under a class action. You can have an employee say, I won't sue you in a class action, which is great. You can't do that quite for a PAGA claim, but you can force that employee to prove they were aggrieved, right? Prove that they had a labor code violation in arbitration separately. And I've done that for clients. Even earlier this year, we successfully proved there were no labor code violations. And so that person's claim, they lose their PAGA claim at that point. If you want these, if you have these in place, you need to make sure that they are properly written because the law is always changing on them. And if you do things like electronic onboarding, you have to make sure you can prove that that employee signed it. And then risk mitigation. All right, now that you've seen all the danger areas and how ugly it gets under PAGA, what can you do? If you are taking reasonable steps, all reasonable steps, even before you get a records request or a PAGA letter, you can basically try to prove to the court that your good behavior entitles you to an 85% reduction in the penalties available. So instead of $100 per employee per pay period per labor code violation, it's $15, right? That's a huge discount and one you should try to avail yourself of. You also, if you take reasonable steps to address these issues, maybe you didn't know about them. After you receive the PAGA letter, you can get a 70% reduction in penalties. So this is one of the most significant changes in this new law from a year ago, is the ability to cut into the potential penalties at issue here. So what are all reasonable steps? Take a look at your policies and practices. Conduct an audit, and do it periodically. Because if you are an employer of a big enough size, you're probably getting PAGA letters or records requests pretty frequently. There's a handful of firms out there that seem to be sending 3 a week, right? The Abramsons of the world and the lawyers for employee and consumer rights. They're just firing letters off left, right, and sideways. So let's check our policies. Let's check our practices. I like to do this with the help of a lawyer because the lawyers work in this regard. I'm not, stumping for business, but you want it to be privileged. Maybe you find some big horrific problems. If your HR person is doing that analysis and that payroll audit, all those documents are discoverable, and you might not want that. So get a lawyer to do it so that it's not discoverable unless and until you want it to be. Discoverable, by the way, means the other side can get their hands on it during litigation. So yeah, if you don't know what wage and hour audits are, it's a decent expenditure. I think we're doing them for $20,000, $25,000, depending on how many employees you have and how intricate your practices are. But it's money really well spent when you see the reductions you can get in a PAGA claim. It's just a look under the hood. It's amazing to me how often I get lawsuits, and this is the first time we've looked at pay codes, and there's a bunch of them that no one can explain that have found their way into the system. That's kind of just the nature of the beast at times. So do these audits, avail yourselves of the penalties. And again, if you get a PAGA notice, what do you do? Maybe you haven't done anything in terms of audits, but now the notice is in hand on your desk. you got to move fast because the penalty reduction situation requires you to take those steps within 60 days. You also have some cure rights, but these are even shorter of fews, right? It's 33 days. You can't cure everything, but there's a handful of things you can. Whether you want to because of the money you have to pay to do it is another question, but get it to the hands of a lawyer who can help you with this as soon as possible because that 33 days flies. It goes very, very fast. Now, if you have maintained your attention since then, you'll see an older picture of me. And I'll turn to some questions. I know that was very fast. It was mile wide and an inch deep, but that's the speed of business. Okay, first question we got, how do you record rest breaks? Well, it says breaks. I don't know if that's meal periods or rest breaks. I'll answer the rest break variety first. I don't like recording rest breaks. I think it's too administratively onerous. I think it creates bad records because employees suck at clocking in and out already, right? You want them to do it now another 4 times a day. We're going to double the time punches. They're going to screw up more and more, and that's going to look like they didn't take their breaks or they didn't take them at the right time. So with rest breaks, I like to just make sure policies and practices are dialed in and that people are trained on when to take them. Some employers, depending on the workforce, schedule them. They put them on the schedule throughout the day. With regard to meal breaks, I like you clock in and out for them. If you're using physical time cards, you probably shouldn't be. Judges hate them, courts hate them. The punches end up looking too perfect, is what judges say. Nobody starts work at 8 o'clock every day, takes lunch from 12 to 12:30, and then leaves at 5. It's just not believable to them. So electronic timekeeping software is probably your best answer. Ms. Torres, to clarify, take the lunch before the 5th hour of starting a shift. Correct. If we look back and go a ways back here, I think. Right? That first meal period should be taking no later than 5.00 hours on the clock. Okay. So they should be clocking out while there's still a 4 in front of the hours worked number for the day. All right. And then the later meal periods are listed here as well. And then let me take a look here. What recourse does an employee have if they clock out and then perform work during the meal period? Okay, so this is unpaid work. The recourse for the employee is they can, and again, this is going to be an hourly employee, they get paid for however many minutes they worked during that clocked out period. So maybe they did 15 minutes of work on this critical task. So they need another 15 minutes. They also need what's called a meal period premium payment, which is 1 hour at the regular rate of pay. So make sure you calculate that properly for the meal period violation. If it goes to litigation, you'll see a bunch of other claims tacked on as well, right? You will see failure to pay minimum wage, and there's a liquidated damage there. You'll see inaccurate wage statements because the wage statement didn't include that 15 minutes or the meal period penalty premium. And there's a penalty there. You'll see waiting time penalties of up to 30 days wages if this is a former employee. And then, of course, attorney's fees are recoverable on all this stuff, even outside of the PAGA realm. So even that small little 15-minute jaunt of work performed can cause you some big problems. And look at that, Rosie, we're right at noon. I can spend a couple more minutes if there are any additional questions. Again, I know that was like drinking out of a fire hose probably, but
yeah, no, I mean, you went through it real quick, but covered every point of it. And to your point, you were talking about exempt employees, what makes a 1099, and as you have experienced, this is a very common factor in construction and staffing. A lot of people will 1099 a W-2, to kind of offset the workers' comp, taxes and so forth. But then if they ever get sued, then they're in a loophole with, that 1099 is actually a W-2.
Yeah, the ABC test is, if you have contractors and you don't know what I'm talking about when I say ABC test, that's not a good thing. The ABC test made it really difficult. It was originally a court case called Dynamics, and then the legislature made it into law, basically. And once they did that, they carved out a bunch of particular classifications, like very particular classifications from this basic test. So it's very difficult anymore in California to classify someone properly as an independent contractor. You can do it, but it takes a lot of lawyering at this point, and I question whether it's worth the work, unless there's particular situations. Construction is a really tough area as well. I don't know if the folks that are in here are generals or subs, but with regard to wage issues, there's a lot of sharing of liability. Even as a general contractor, even if you've properly retained a subcontractor to do work for you, oftentimes you can be held liable for the subcontractor's failure to pay their employees. And
really? Actually,
absolutely.
that was one of the questions yesterday on my comments on this event. They asked, someone asked, what happens if the subcontractor doesn't pay their employees on time because the general contractor didn't pay their sub on time?
Yeah, there's a specific labor code section on it. I'm sure you'll all be happy to know. So it's tough. And with staffing, there's also a specific labor code section, 2810.3. You're considered a labor contractor if you're what you might call a temporary staffing or employment agency. And the company to whom you assign your workers, because you're the employer of record, is called the client employer. And Labor Code 2810.3 states that the client employer and labor contractor are jointly and severally liable, meaning you're both on the hook for issues arising from failure to pay wages. And so client employers think, that's not even my employee. Why am I in the mix here? There's two reasons. One is that labor code section, and the other is it's probably a joint employment relationship, which is a legal test. Are you scheduling these people? Are you directing their work? Well, then, yeah, you're one of their employers. So there's 6 different ways for the plaintiff's counsel to get after you in California, unfortunately.
Wow. So what happens? I've seen cases of PAGA where there's one, big company, but they work with multiple staffing agencies, and I've seen up to 20 staffing agencies named on one PAGA claim. What happens with in situations like that?
Well, from the plaintiff's perspective, what typically happens is they name everyone. They just put everybody into the complaint, and they don't care where the money's coming from. They lump everybody in as a defendant, and they'll let the defendants sort the bodies amongst themselves. Really, it often comes down to who can afford it and who's going to pay it. And but yeah, you can have cases. I've got one right now where one temp employee worked at 3 different work sites, and the plaintiff is trying to go after my client, the staffing agency, and those 3 work sites all in one lawsuit for PAGA and discrimination and all kinds of other stuff. It's one of the most convoluted lawsuits I think I've ever handled in this scenario. So yeah, it's those become tough, but it doesn't get you out of the hook or off the hook just because it's complicated.
Yeah, and then there was another question from Instagram. Someone asked, what are the consequences if I had paid my employee with cash?
All right, so there are potentially a lot of consequences, probably, and it's going to depend on the other kind of practices that are at issue. If you're paying somebody for cash, I'm guessing you aren't keeping accurate time records of that person's work. If you're paying cash, you're not processing them through payroll. That's my assumption on this. So you're not withholding proper taxes and things of that nature. You're not making uninsurance employment contributions. It creates a lot of problems. The employee obviously is going to have claims for, wage issues that you're not going to be able to disprove because you don't have the records, and the burden of proof is going to be on the employer. If they go file for unemployment, the California EDD is going to look for an account with their name on it, not find it. They might come knocking. They might audit you. The IRS can do that as well. It's that's the big bad wolf. I don't think anybody wants the IRS knocking on their doors and opening the books. So it's definitely not recommended to pay employees in cash.
Yeah, you'd be surprised how many contractors still follow that. That's
Yeah,
sad.
no, there's certain industries where policies that would give me great amounts of heartburn, or approaches to things, right? Somebody showed up for the day. All right, give that guy a couple $100 because he did the work, and carry on. And that's been happening for decades, and it'll continue to happen. They're almost insulated from the plaintiff's bar. But we see them moving through different industries. For a long time, it was delivery drivers, right? The FedEx delivery drivers and Amazon drivers were all classified as contractors. And for a good number of years, that was just getting hammered over and over by plaintiffs' counsel because legally they shouldn't have been contractors, even though they had been for forever. And we saw them run through mortgage loan officers, and we saw the plaintiffs' bar run through the misclassification of restaurant managers or assistant managers at grocery stores because they were classified as exempt, but they weren't doing exempt work. So it's just a matter of time. The Halloween theme, it's coming through a lot here, but you're whistling past the graveyard if you're doing that. Don't do that.
Yeah, most definitely. Well, everybody, so if you guys have any questions, go ahead, comment them. We're going to be here for you for the next 2 minutes or so. We don't have to receive anything else, but thank you so much, Brandon, for coming on. I really appreciate you taking your time. And I tell everyone, do audits because there's not much, it's a scary place to be once you get served, and knowing how much you may pay. It's just, and especially if you don't have any of the documentation, it just puts you in a really bad scenario.
Yeah, I agree with that. It's an ounce of prevention more valuable than a pound of cure, and that really is the case with these PAGA lawsuits. It's worth the expense. You don't know what you don't know, and so go find out in a manner that's not in the bright light of the courtroom, because a PAGA case really is a payroll audit. It's just you're paying for it both through your own counsel, and you're paying for the plaintiff's attorney before it's over as well.
Yeah. And then where can people reach you out for your services?
I've got my email address and phone number up there. You can Google me, I'm sure. Hopefully this is the only thing that pops up. Try to keep a pretty clean record online. And yeah, I can send this slide deck to you, Rocio, and you can circulate it to the attendees, and be happy to help if anybody needs it.
Sounds good. So everybody on the event, there's I will copy and paste his information. His LinkedIn page is also linked to the event page, so you guys can go ahead and follow him. And once I get the slideshow, I will distribute to everybody that signed up for it. But thank you so much, Brandon. Really appreciate you for taking your time going through this and helping employers how to navigate this horrible nightmare.
Happy to help. This is my bread and butter and what I do. So always like to share and help people stay out of trouble.
All right. Well, thank you so much, guys, and I hope you guys take care and have an amazing Halloween. Here you go.